for that matter, once you became lawyers, ever read the preamble to the Constitution of India? Most of us, I think, never read the preamble. But if you see the preamble, it encompasses the idea of India. It encompasses the concept of justice, social, economic, political, liberty of thought, action, faith and belief, and equality of status. So in the one preamble which was voted today on 26 November 1949, 26 November 1949, India gave to itself an idea, a broad-based idea of what the nation must move forward to. As I stand today, I look at the functioning of one of the most important pillars in the Constitution, the judiciary. There were a lot of anarchy caused by the partition, caused by communist insurrections. And the question was, how does the Constitution move forward? Does the man who breaks the law be incarcerated under the preventive detention laws, or does he have a right? And I quote to you from the judgment of Justice Vivian Bose, one of our great judges. In the judgment in Krishna, it is not reported in AR or SCC. You find it in the SCR. I found it while doing research on freedom of speech. And this is what Justice Vivian Bose had to say. It is perhaps ironical that I should struggle to uphold the freedom in favor of a class of persons who, if rumor is to be accredited and a list of their activities furnished to us is true, would be the first to destroy them if they had but the power. But he says that is not our rule. Our rule is to protect the Constitution. So therefore, in the first formative years of the Constitution, the courts were guiding and leading the Constitution so that freedom becomes effective, trade and commerce becomes effective, and our courts played a stellar role in this development. Then came the second phase of the Constitution, when the very concepts of India were being attacked, judges were being transferred, things were being done by, of course, by the political parties in power. And the court developed the concept of the basic feature of the Constitution in Keshavananda Bharati and thereafter reflected in the Minerva bills. Now this concept, we assume, has built us and given to us a Constitution in which the preamble concepts will be protected. But as my good friend Aspi has said, it's not the Constitution, the preamble concept, it is the minds of the people and what is in their mind that will ultimately we think about. Of course, in the 70s again came the time when we had, I always said so, I said so in a speech when I was a secretary or a student, a lawyer. We had a conference in Goa and Justice Chandruchu was there. And I did say the ADM Jabulpur judgment is something that to any right-thinking lawyer, to any right-thinking citizen, is a black mark on the judiciary as such, but except for the dissenting judgment of Justice H.R. Khanna, which shines and has been reflected thereafter. Then we have come into the third phase, where the laws, the courts advanced the laws on the right to life. Article 21 saw a new dimension. Article 21 was no longer rooted only in the pages of the Constitution. It broadened out. We looked at international covenants. We looked at the directive principles which were unenforceable. But then courts developed this theory that they can be read into the fundamental rights. And so Article 21 in the fields of environment, in the field of ecology, in the field of women's rights, in the field of child rights, saw this evolution by the courts of Article 21 over a period of time from the 80s onwards. Justice Bhagwati developed the concept of the PIL petition. The PIL petition was developed to help those who could not reach the courts. Of course, today it has attained a view which is sometimes totally different. We have difference of opinion upon it. Some use, and some are using it as a means to control governments. So therefore, the evolution has taken place and the law has developed. But there is one consideration that we have to think. Though our laws provide for a democratic society, and I wish the Supreme Court at some point of time would enter into this arena, because in the doctrine of separation of powers, the Speaker is supposed to be exercising his own powers. But right from the judgment of Sheriff of Middlesex, and thereafter we come to the UP judgment and subsequent judgments, courts have interfered with the decision of speakers. My only hope is that some point of time, the Supreme Court also will put a timeline on speakers to decide the issue on defection. For that defeats the very concept or the idea of democracy. If you are elected on the part of one party, you defect and the matter is kept pending for a long time. I'm sorry that some of my judges will be there. There have been matters before them, it's not because for you. I'm speaking on the larger, broader issue. I myself was a part of the system and I've always felt so. So this evolution, I think, is required, and with that, I think there is some further part of the function still remaining.
Right from the 1930s onwards, to a very strong class which believed that nationhood could not be only on the basis of birth or domicile, but had to be rooted in religion or culture. This conflicting stories has been the hallmark of Indian constitutional development from the 30s till today. But a choice was made in 1950. The Indian Constitution adopted birth and domicile and not any other form as the basis for citizenship. The Indian Constitution predicated equal treatment of all religions. I must clarify because it comes later on. Secularism and secularization are two different concepts. Secularization comes from the European concept of separation of state and church. India has never really been complete separation of state and church. But the Indian concept of secularism has always been equal treatment of all religions. For example, you fund the Hajj and you fund the Sevas and the Mahakumbh. And the constitutions don't live in an abstract world. They live in competing political and social views. So it is very important to appreciate the context in which the constitution came up. In the 1940s, Muhammad Ali Jinnah and Veer Savarkar were both proponents of a two-nation theory for different reasons. But as Neeraja Jayala, political scientist, writes, the difference was that Jinnah wanted the territory of undivided India to be cut into two, with one part for Muslims and the other for Hindus. Whereas Savarkar wanted Hindus and Muslims in the same land, but with Muslims subordinated to Hindus. The partition of India in 1947 emphasized the great importance of secularism, as even after partition, a large Muslim minority consisting of a tenth of the population continued as citizens of independent India. I don't know if you realize that we have the second largest Muslim population in the world, far more than Pakistan. Next to Indonesia, India has the largest Muslim population, 120 million or something like that. There were other important minority groups of citizens. In the circumstances, Gandhi, Nehru, Patel, Ambedkar thought it was important that India have a secular constitution, a constitution which all religions could enjoy equal freedom and all citizens equal rights. The Hindu nationalists at that time, belonging to the Vishwa Hindu Parishad and the RSS and their pre-runners, had a little different world view of India. They saw India as a nation state, not a multicultural one. They saw India as a nation state which could only be a unified state if it focused on Hindu beliefs and culture. Accordingly, in 1947, at the time of independence, there were two competing visions of India. We hear this phrase nowadays, the idea of India. It's something like that. One was a secular state where birth and domicile defined citizenship. In other words, if you were born in India and you were resident in India, then that was your basis for constitutional citizenship, irrespective of your religion, your culture, etc. And then we had the Hindu Rashtra concept, which said that the state had to be viable, had to be based on Hindu beliefs and culture. At the time of independence, in 1947, and in the formation of the Constitution of India, those who saw India as a plural secular country clearly prevailed over those who wanted India to become a majoritarian Hindu state. Now mark the interesting part. 80% of the Constituent Assembly was Hindu. So only with their concurrence and the persuasion of leaders like Gandhi, Jawaharlal, Ambedkar and Patel, would you have a situation wherein 80% in the Constituent Assembly ceded a right to have a Hindu state and agreed instead to have a constitutional state. It's something which requires to marvel at, because it's not an easy phenomenon. The world around us has become majoritarian and unitary. India was one of the rare cases where a majority, an overwhelming majority, agreed to make this state a constitutional state. As Dr. Ambedkar said in the drafting committee, adequate safeguards were required to be provided to protect the secular character of the country and to check divisive forces. So he weaved Gandhiji's concept of secularism into the form of composite culture that in India meant secularism. And he particularly, of course with a lot of support from Patel and Nehru, ensured that the constitution defined the nation politically as comprising those who inhabit sovereign Indian territory and as a place where all Indians are equal. It was birth, circumstance and domicile and not religion or culture that defined Indian citizenship in 1947 and 50. This did not go down well with Gorwalkar, and he made a statement in 1947 that India's freedom from colonial rule was no real freedom because it was founded on, and I quote, a perverted concept of territorial nationalism. And he felt that a citizenship divorced from religion or culture could not stay. Rajmohan Gandhi analyzed the outcome of 1947 rather well. He said what took place in August 1947 was not the creation of two nations, one Hindu and the other Muslim. It was the separation of contiguous Muslim majority areas in the subcontinents north, west and east. Undoubtedly, Pakistan chose to become an Islamic nation, but India remained a nation for all with equal rights firmly entrenched in its constitution. The problem is the time of secularism has gone. It's not that the time of the UCC has not gone. We are looking at a far more fundamental problem. And if that can't be resolved, then you may have all the uniform codes you want, but they are never going to be neutral codes.
Right.
I must say one thing, that while I critique Hindu fundamentalism, I think it is a darn sight more palatable than Muslim fundamentalism. So don't get me wrong on that. I would much prefer to live in a Hindu fundamentalist state than a Muslim fundamentalist state. But I would prefer not to live in a fundamentalist state. Let me put it correctly.
So one question on minority rights. Has it caused any problems?
Of course, because since the 1990s, the narrative has been that minority rights is appeasement. And that is allowed. You see, I will digress for a few minutes. Hinduism essentially was heterogeneous. It has never been a cohesive political force. Savarkar saw it in the 30s. He said that if we do not unite on a few religious principles and a few cultural beliefs, we will never be a political force. The attempt has been to consolidate a Hindu vote, just as attempts have been made in the past to use a Muslim vote. And the concept of minority rights has been used as a whipping boy to talk of the necessity of Hindu consolidation.
Yes. Now one more like this. Secularism, why is it considered to be a positive attitude?
Secularism in India was Sarva Dharma. It's treat all religions equally. It was not the separation of church and state. Amount of money spent on the Hajj by the government, amount of money spent on the Kumbh Mela. So long as there was a broad equidistance, secularism meant equal treatment. The secularization is a completely different concept. India never believed in secularization. India believed in secularism meaning equal treatment, and the constitution based not on religion but on birth and domicile. That is, you see, when you say is that good or bad, that goes to a value system. If you are a fundamentalist and you believe that a religious cultural state is a strong state, when you look at how constitutions were framed all over the world, contentious issues were always deferred to an aspirational part of the constitution. Matters which you could not resolve at the heightened tensions of that moment were put in aspirational parts. Our part 4 is an aspirational part. It was hoped that when tempers of partition cooled, when education and economic prosperity increased, then people would be able to have a rational discourse to bring this about. But it is not worked that way. In fact, polarization is more heightened today than it was in those days. And in a polarized atmosphere, it is very difficult to get the trust of communities. And what would otherwise be benign or might be possible is looked at with great suspicion.
What is your solution to protect secularism? That is the last one.
I don't have a solution. I only have faith and hope that in the strength of India, somewhere I remember, I do believe that India gets its secular feelings because the Hindu is secular, by and large. So all these years, all these communities, including Parsis, came into this country, settled down, they were never harassed, they were allowed to live their lives in peace. India got its strength from its lack of homogeneity and from its willingness to live and let live. It is the political class which has changed that. In the last 10 years, passions have been whipped up, which has changed the view many Hindus look on us. And they feel they are getting shortchanged in their own country. And that creates this political mobilization. This is a very difficult thing. Don't forget that the BJP had 2 seats in 1985. And it did not have any seat in the Constituent Assembly. But they worked hard to be where they are. If we need to counter that, someone will have to work as hard. It's not going to be short term, it's not going to be easy, and it might not even happen. But then I don't see any short term solutions to this.
Last one. Your views on the Sabrimala journey.
and I have not studied it. So, but I believe it falls in the same genre. Everyone wants to say that my faith allows me to do something which the law might not otherwise think is good or bad. Everyone does it. And it's, as I say, it's competitive communalism at its worst. And each time it weakens the state. It weakens the fiber of the state and it weakens the basis of the state. But everyone does it. Today, tell me someone who's not a soft Hindutva in politics. Everyone is doing it. Because every politician wants power. And power requires a load which you can live by and go by. If Mr. Kejriwal recites the Chalisa, if Rajiv Gandhi says the Janu going temple going man, if the lady in Calcutta also mentioned, it's because the mood of the country has swung to a level where it's very difficult to contest an election if you say you do not have religious affiliations. It's sad, but it's true. My belief today in giving this speech is that we tend to say that if we don't talk of it, it's not there. But it's there. And we need to realize that in many ways we are near the 22nd and the 23rd hour.